Tonight, Jules Lobel talks at Arizona State University about his work in defending the constitutional rights of prison inmates.
If we said everybody, this is unconstitutional for everybody, we've been running smack into precedent. So what makes it unconstitutional? States said it's only unconstitutional if it drives people mentally ill. That's the kind of harm. Driving somebody mentally ill. So they said, if you can prove that your client's seriously mentally ill, then it's a cruel and unusual punishment. Our position was, we had a number of various positions. One is that at bottom, the Eighth Amendment is about human dignity. And if you read the most recent Supreme Court case on the Eighth Amendment, context of prisons, also coming out of California, Justice Kennedy says, at the heart of the Eighth Amendment is a violation of human dignity. It is a violation of human dignity for people in this kind of situation, irrespective of whether it drives them mentally ill. That's number one. Number two, the Supreme Court has said depriving people of a basic human need is a violation of the Eighth Amendment. You deprive people of sleep. You deprive people of food. You deprive people of medical care. You deprive prisoners of exercise. All of that are denials of basic human needs and leads to a violation of the Eighth Amendment. Our fundamental claim was that there is a basic human need to interact with other people. We are social beings. Part of our basic makeup is that we want to talk, we want to interact with other people. You take away the ability to socially interact with other people, and you're stripping somebody of what it means to be human. And that should be considered a basic human need in the same way as food, exercise, shelter are basic human needs. And we brought in a team. We had 10 experts, including a neuroscientist who had written a book on this very issue, not involving prisoners, but involving how humans have a basic need for social interaction. We brought in social scientists, psychologists, psychiatrists, all of whom testified to the same thing. And interestingly, our lead expert, a psychologist, who had been the expert back in the case, the Madrid versus Gomez case before Henderson. And he found 7 prisoners. We found 7 prisoners, but he interviewed 7 prisoners who had been there in 1992, and he had interviewed back in 1992. He interviewed them 20 years later. They were still there. And interestingly, their specific condition had not deteriorated. Hadn't gotten any better. They had gotten adjusted to this. So they didn't go crazy. But they had lost a sense of connection to other humans, connection to the outside world. It was like, what he termed it was like social death. That you weren't being killed in a physical way, but you were being killed in a social way. And a wonderful philosopher, Lisa Gwenther at Vanderbilt, has written a whole book on this concept of social death. So that was our second perspective, and the courts are starting to inch towards recognizing a basic human need of social interaction. The third thing he said is that there is substantial mental harm. You know, the mental harm doesn't have to be driving people totally crazy. You can cause people substantial mental harm by putting them in these conditions, even if they somehow adapt. And what our psychologist, Craig Haney, said, people have tremendous powers of adaptation. But some adaptation is pathological itself. And this is what happened here. That what they were able to do is adapt by saying, here's my routine. I wake up at 8 in the morning, or 7 in the morning. Most of them didn't sleep very well. But I do some exercise on my own. I watch TV, I read a book, and then have lunch, whatever I do, but they had lost the connection to other human beings. Well, that's pathological adaptation. But all of them suffered from depression, hopelessness, paranoia, panic, aggression, anger. They all had a series of symptoms which psychologists would say are psychopathic, even if they weren't mentally, seriously mentally, even if they were still functioning. One of the problems in American law, particularly in this area, is that we undermine or we devalue the notion of mental harm. So, for example, you probably, hope you remember, we should all remember, what happened at Abu Ghraib in Iraq, where American soldiers and contractors put these prisoners naked and forced them to do all sorts of terrible things. If that had happened in an American prison, those prisoners would have had no claim for damages under the Eighth Amendment. And you say, how could that be? How could that be? The Prison Litigation Reform Act, a statute enacted under the Clinton administration, says that in order to get damages for an Eighth Amendment violation, you have to show physical injury. So if my clients were suffering physically, if they had instead of putting them in solitary, they chopped off their hand or something, well then, that's an Eighth Amendment violation. But the mental harm is not as well recognized, both in American law and the way we view international human rights conditions. But that was our argument, and we had substantial experts to prove that these folks were suffering long-term mental harm, even if they were not driven crazy. Our next argument was that this also creates physical harm in many prisons. Here, there is an interesting development in social science. There have been over 100 studies of primarily older adults, both in the United States and England, who are socially isolated, who don't have friends. They're not prisoners, but they're not locked up in this situation. They just are lonely. They don't have friends. They don't have a social network. And they've done studies about the relationship of social isolation and various diseases, most prominently hypertension and heart attack. And the risk factors for heart attack and hypertension from social isolation is as great as from smoking and obesity. It causes, or it's correlated with, hypertension and heart attacks in adults. And we were able, through discovery, to get figures on hypertension for a similar group of prisoners, because Pelican Bay has a general population prison. Maximum security, high security, the general population. And the special housing. And it turned out, we had a social scientist who had done some of the leading studies on this. It turned out that the rate of hypertension is much greater among the shooters. So, social isolation, I think from all the scientific and anecdotal evidence, is as great a problem as physical torture. John McCain was kept in solitary when he was a prisoner in Vietnam. And he has said that the worst part of his imprisonment was not the physical abuse, but the mental abuse that occurs through solitary confinement. He said it breaks the spirit more than anything that was imposed on him. Sailors, there are some people, I don't know what causes these people to do it, but they like to go across the ocean on a sailboat, for weeks and weeks and weeks. Why anybody would want that, I don't know. But they do that. And when they get back, they interview these people. And they say the most horrifying aspect of it most difficult aspect of this was not the 40-foot high waves, not the sharks, not the lightning storms that we faced, but what one sailor called soul-crushing isolation. And that's why I think this violates the Constitution. We were going to go to trial right now. Well, I would have been in trial in 2 weeks. But California, after 3.5 years of stonewalling us, through 3 hunger strikes, the third hunger strike, 30,000 prisoners went on hunger strike. California budged not an inch. We won a motion, we beat back a motion to dismiss. Our class was certified, we had discovery. We were, and California was moving towards some reforms, but very minimal. They finally came to us and said we're interested in settlement. And just recently, 3 or 4 months ago, we settled our case with California, because even though we were all actually looking forward to a trial, as was our clients, California agreed to end the policy of placing people into solitary for gang membership. No more. They agreed to review all of the thousands of people in solitary for gang membership. And if they didn't have a serious offense in the last 2 years, they would get out of solitary. They agreed to essentially get rid of indeterminate solitary. So from now going forward, there's still going to be solitary. And I disagree with that. I think that long-term solitary confinement is a violation of the Constitution, but it's only going to be if you commit a serious behavioral violation, like assault or murder or something like that, and only for a limited, fixed period of time. In addition, we argued that you have to come up with an alternative. Because what California and every other state says is there are some people, Hannibal Lecter, who are so dangerous you can't let them in the general population. And my client said, okay, well, you can come up with a system that segregates people from the general population who are really dangerous, but doesn't put them in total isolation. You know, where they have some small, they're not in a big yard where they can create a fight or a riot, but they can be in a small setting with a couple of other prisoners, which are heavy security. They can have programming. They can have telephone calls. Why shouldn't people have telephone calls? What's the security? They can have windows. They can have contact business with their family. They're not going to assault their family, or very unlikely. And California agreed to set up an alternative unit like this. Segregation from the general population, but with general population privileges. And we'll see how it's going to work. Particularly for those people who've been in solitary for a long time, who California felt was still too dangerous to let out. They're not going to put them in the general population, but they're going to put them in a general population setting. They're going to keep them out of isolation. They'll be separate from the general population, but not in these kind of draconian conditions. I think the key thing in this situation is coming up with a formulation that allows for separation without isolation. And the last thing I want to talk about, just for the last few minutes, is our approach to this settlement and our approach to the whole litigation. We took the view that what our clients were really being deprived of was basic humanity, basic human being. And part of the lawsuit, the process of the lawsuit, had to be restoring that, irrespective of the substantive remedy. So when California, when we first started mediation, we tried for a year to mediate this without any success. we came to the prison officials and we said, you know, a basic thing is we want to develop a proposal settling this. And that means that all 10 of our named plaintiffs have to get together and discuss it. And they said, no, that's not possible. That's not possible. We don't let these people meet together. You can go individually, to each one of them. You could say, that's lawyer driven, not client driven. We said this has to be client driven. It has to be coming from them. And the only way to do that is to set up a meeting. They said no. We went to the judge. The judge said we can't possibly have mediation or settlement without your clients being able to discuss it, and ordered it. And we had 2 3-hour meetings. And if you can imagine the situation, I was at a table like this, sitting like this, and around me were 10 what appeared to be telephone booths, but they were therapy cages. And each person was put in one of these therapy cages. It was not a normal meeting. And even in these therapy cages, which they could not get out of, they still made me wear a green beret flak jacket, just in case somebody had smuggled in a knife and somehow got out of the telephone booth and decided they wanted to attack us. It was all symbolic. You know, these folks are so dangerous that you can't even be there without it. So, and for 3 hours, we came up with proposals. And eventually, the basic gist of those proposals is what California agreed. When California then came to us and said we are interested in settling it back in the summer, we said, by this time, a number of our plaintiffs had been moved to different prisons. We said we still have to meet with all of them. And we proposed a conference call. And they gave us 4 or 5 conference calls over the course of 3 or 4 months, where our prisoners' clients evaluated California's proposals, came back with their own proposals, and this is what's acceptable. So it wasn't that the lawyers were just settling this and then bringing it to them for ratification. They were involved in the process. And in fact, in the settlement, one of the key things we fought for was that the clients, that the prisoners actually should participate in the implementation of the settlement. There's going to be programming, and the nature of the program has to be discussed between California and not just the lawyers, which they were perfectly willing to do, but California and representatives of the prisoners themselves. California is going to create a panel of experts. The experts have to meet with the prisoners themselves. Every 6 months, the California prison officials have to meet with representatives, not just the lawyers, but of the prisoners themselves. And we got the right to a couple of times have another one of these group meetings, conference calls, to discuss what the prisoners believe, how it's going. So I just end with the notion that doing this to people really deprives people of their basic humanity. Part of litigation should not just be winning substantive forms, but actually overcoming the problems, barriers that people have faced. And this was one of them. I want, as part of what we did in this case, we tried to humanize and present to the public the voices of our complainants. At the beginning, there was no way of getting their voices out. So what we did was we took statements from them, and we publicized that in op-eds on our website. Later on, after each of our clients were deposed, we had video depositions. And the New York Times did a front-page Science Times story on this case and the expert witnesses and psychological. And they made a 5-minute film clip on our plaintiffs testifying at their depositions. Very, very powerful. Go to the New York Times website, look up Erica Good, who's the reporter, or look up Pelican Bay, and you'll get to this story, and you'll get to both the expert reports and this 5-minute video. We also did a little longer video using the same deposition material, which is on the CCR and the Senate Vice President. And by the way, one of the most poignant moments in those depositions, one of our clients, African American in full red, said, a very powerful, strong 60-year-old man, said, you know, it's not, I'm not mentally ill, I'm not suicidal, but he says, every day is a struggle, and he says, sometimes I wake up and I just want to write to the judge, saying, why don't you just give me the death penalty? I can't take this anymore. And then he starts to cry on the film. I want to end, though, by another one of my clients, Richard Johnson, who wrote the following. Being in prison is an ordeal, to say the least, but the security housing unit is an altogether different form of punishment. Coming to the SHU has opened my ideas to the harsh reality of physical and mental torture. Before this, I only had a vague idea what mental torture might be like. Now I know it is 10 times worse than I had imagined. It is a challenge each day just to remain sane. I experience a wide and shifting range of emotions, including depression, hopelessness, antipathy, anxiety, and humiliation, and I have chronic insomnia. Under no circumstance should anyone be treated like this. We are human and should not forfeit basic human rights because we are in prison. Of course, everyone should be held accountable for their actions. However, punishment for a crime should never amount to torture. It would be easy to respond to this treatment with the same cruelty and malice that is administered daily to SHU prisoners. Constant disrespect can make someone a hateful monster, and many have been irreparably harmed by this experience. I struggle not to fuel the problem, to keep my wits about me, even when I feel I may descend into madness. I hope this cruelty never shapes my ability to remain a human being. That's the struggle, and that's what we try to do throughout this litigation. Give people hope, give people their humanity back. And that's, I think, the struggle of these prisoners. And they were, I think, in part able to do this because of their resistance. 30,000 prisoners going on hunger strike took some courage and resistance. And the Navy did a study once of POWs, and they found that the most important aspect of POWs staying sane was their ability to resist psychologically the oppression that we resist. But anyway, I end with Richard Johnson's remarks. Hopefully, we've got 2 years of implementation of the settlement. I'm happy to answer any questions both about the settlement or anything else on this